Preparing legal documents like power of attorney for your loved ones can be stressful, but that pales in comparison to how stressful it can be to not have it in place when you need it. This is especially true if your loved one suffers from dementia or other cognitive diseases. In this video, we're going to discuss why it's important to have a power of attorney in place and what happens when you don't. Hi everyone, and welcome to the channel. I'm Rob King from Valley Senior Advisors. We help seniors and their families find the best senior living options in the Phoenix area, and our services are 100% free. Before we get started, download the Essential Arizona Assisted Living Guide for free at valleysenioradvisors.com/assisted living guide, or click the link in the description. Also, hit the subscribe button and the notification bell so you don't miss any future videos. First, a quick disclaimer: I am not an attorney, and this information should not be taken as legal advice. The purpose of this video is to provide general information about why having a power of attorney in place is beneficial for those with dementia and other cognitive impairments. Please consult with an attorney before making any legal decisions for yourself or your loved ones. With that out of the way, let's get into it. So first, what is a power of attorney? A power of attorney is a legal contract where a person referred to as the principal voluntarily authorizes a trusted person called the agent to act and speak on their behalf. Power of attorney can be limited to certain activities like allowing the agent to access their bank accounts, or it can be general and authorize any and all necessary access to a principal's affairs. Many power of attorney agreements don't take effect until the principal is certified as incapacitated by a medical professional, but there's also agreements that immediately grant authority to the agent. There are two types of power of attorney agreements: a financial power of attorney and a healthcare power of attorney. A financial power of attorney authorizes an agent to manage the principal's assets, and a healthcare power of attorney designates the agent to make healthcare decisions. With a healthcare power of attorney, the agent has the right to speak with the principal's doctors, access medical records, and make important medical decisions on their behalf. Both power of attorney agreements are utilized to move the principal into senior living. The healthcare power of attorney allows the agent to determine that assisted living or memory care are in the best interest for the principal's health needs. The financial power of attorney allows the agent to use the principal's assets to pay for their care. Luckily, power of attorney agreements are pretty easy to create. It starts with a quick consultation with an attorney who will help you decide what details need to be included in the agreement. The attorney will then draft the document, and the principal will sign it in front of a notary. If you don't have an attorney to use for this process, we know a couple of great law firms that specialize in this area. Reach out to us and we can provide you with a few firms that we would recommend. So why is it important to get power of attorney in place sooner than later? The reason is the principal needs to be of sound mind in order to grant power of attorney to their agent. A person with dementia may not be of sound mind depending on the severity of their disease. A way to gauge if they're capable of signing a power of attorney is to ask them a few questions to see if they understand. You can ask them, what is a power of attorney? Why do you need a power of attorney? Who does the power of attorney authorize to be your agent? What will the agent be able to do for you? And when does the power of attorney take effect? If they're able to answer the who, what, when, and why about power of attorney agreements, it's likely safe to assume they have sufficient mental capacity to sign a power of attorney. If a person can't answer these questions and is not of sound mind, there are some alternatives to power of attorney, but they're a bit more complex and take longer to get into place. These alternatives are guardianship and conservatorship. In a guardianship, the guardian is granted authority over a person's healthcare and living situation, which includes things like living arrangements, day-to-day care, transportation, and food. In a conservatorship, the conservator has authority over a person's financial affairs. Guardianships and conservatorships can be general or limited. In a general agreement, the guardian or conservator has authority to handle all of a person's affairs. In a limited agreement, there may only be certain activities or specific aspects that the arrangement applies to. To put a guardianship or conservatorship in place, you'll need to petition through the court system. In addition to taking longer and being more complex, it's more expensive than a power of attorney. It also requires much more ongoing accountability from the court-appointed agent. Once a guardian or conservator is appointed by the court, they're required to submit an annual accounting of their activities. If the court determines that the guardian or conservator is not abiding by the agreement, the court can remove them and appoint a new guardian or conservator. So as you can see, it's much better to be proactive and establish a power of attorney if possible. It can save a lot of time and expense down the road by avoiding agreements that go through the court system. I hope this information was helpful, and if we can do anything to support you, please give us a call. If you liked this video, hit the thumbs up and subscribe to the channel. Hit the notification bell to be notified of when we post new videos. YouTube thinks you may also like this video. Go ahead and click it and let us know what you think. If Valley Senior Advisors can help you find senior living, give us a call. Until next time, take care and we'll see you in the next video.